Hi, thank you for joining us. My name is Audrey Thornton, and I'm an attorney at Housing and Economic Rights Advocates. And I'm joined by my colleague today, Megan Grimm, who is also an attorney at Housing and Economic Rights Advocates. Today, we're going to do a workshop on the rights of survivors of domestic violence regarding homeownership. So I will pass this over to Megan to start.
Sure. So just as a quick disclaimer, we're doing this talk in partnership with the Sacramento County Public Law Library. We love being able to reach out all over the state of California. And although we are very excited to provide this good educational content, this presentation is just for informational purposes only. So if you have specific needs or specific questions, you can always call the Sacramento County Public Law Library, get HERA's information, or you can call HERA and we'll provide our contact information at the end. All right, Fabi, next slide. So here's just a bunch of different resources. Here's how you can contact HERA, and here's how you can contact the law library. Next slide. Awesome. So let's get right into it. So like Audrey said, we're talking about domestic violence survivors' rights regarding homeownership. There's a lot of unique issues that come up when you're a homeowner and you're a survivor of domestic violence. There's some tricky things that you want to get through, and the goal of the presentation today is to give you the knowledge and the resources to get through all of these situations. Next. So first, you want to know your rights. When it comes to getting a move-out order, which is an order that would essentially kick the abuser out of the home, what do you do? Or if you need help paying the mortgage and your financial situation isn't exactly what you want it to be, or you need some help, these are the questions that we're going to go through. We're going to help you figure out how to obtain assistance paying the mortgage, what your options are if the abuser and survivor both own the house, what your options are if the survivor is not an owner at all, and what your options are if the survivor is a sole owner, which can bring on its own trickiness. Next, we're going to talk about options for survivors who have coerced debt and how to protect and improve their credit. And we're also going to finish out with protecting bank accounts from an abuser. Next. And finally, we're going to talk about protections that are available for survivors with regard to HOA and code enforcement. Living in an HOA community can also bring some issues that you should know how to handle as you're moving through this process. There are some crime-free ordinances and balancing of survivors' rights that you should keep in mind when negotiating and handling your HOA. Next. So step one, taking a step back. How do you get the abuser out of the home? Say you're a survivor and for your own safety, you want to get the abuser out of the home and stay in your home. The first thing you're going to want to do is apply for a domestic violence restraining order. This is absolutely free. The court can grant this move-out order, which is also known as a kick-out order, as part of a restraining order. Can also make other orders to protect you, such as giving your temporary possession of your property, and can order the abuser to pay mortgages or other debts, which is good to know. The move-out order officially will require the abuser to move out of the family home or the shared home. Next slide. This is an example of what the form looks like. You see that little box right there? You would just check that item 13 on the form, which is to request the order to move out. I ask that the judge order this person to move out of the home, put the address, and then you would say why you have the right to live at the home. Either you own it, your name is on the lease, or you live at the address. Next. This is another example of that domestic violence restraining order form. This is where you would ask the judge to give only a survivor temporary use, possession, or control of the property listed, and then you would explain why. Now, if you're confused and you don't know what to put here, that is exactly what we're going to go over in this presentation today. Next slide. So what if you're not an owner? What if you're a survivor and you obtain a move-out order successfully, but you don't own the home? Can you get a move-out order? Yes. So to receive a move-out order, you have to show the court all three of these things. The first you have to show is that you have the right under the color of the law to use the home. Next, you have to show that the abuser has assaulted or threatened to assault you or your children, or someone who lives with you and depends on you. And third, you have to show that you or your child or dependent will be physically or emotionally harmed if the abuser lives in the home. Even survivors who are not a named party do not have to pay the rent or on the lease or are not listed on the deed, have a right to request this order, but you have to show all three of these things. Next slide. Now, you may have caught that I said right under the color of the law. If you're not listed on the property deed, you may have a right under the color of the law, which means you pay the mortgage or you contribute to payment of property taxes, or even if you're not financially contributing, you can contribute to the household in other ways, such as cleaning or buying food for the household. That would be something you would put in the form about why you have a right to live there under the color of the law. You have to give the court any proof of your right to live on the property and attach this proof to your HERA request and explain your housing situation to the judge. So if you made property tax payments, you have a receipt, you could attach that. You can say, I made property tax payments, therefore I have the right to live in this home. Next slide. Another thing you can attach besides receipts, like I mentioned, would be screenshots of online rent transfers, or if you have a utility bill or other bill in your name that goes to the house, or any proof that you have that you use this address. Of course, only a judge can decide if you have a right to use the home, but these are all things that would help you show that you have a right under color of the law to live there, no matter who holds title to the property. Next slide, please. So next question we're going to answer is, can I obtain a move-out order if I'm a survivor and I already left? So things that we sometimes hear from callers are, oh, I already left the family home. How can I get a kick-out order if I'm not there? Well, you can. Even if you moved out of the shared home to escape abuse, you could still ask for that move-out order and then just move back in safely. It's not required that you give the court your new address. You can always just write confidential, and you don't have to put it on your filings. Next slide. So let's say that you obtained a move-out order. How do you enforce it? Luckily, there are ways that you can enforce it without putting yourself in danger. You can have a police or sheriff enforce an order once the abuser receives a copy of it. The sheriff would therefore serve the order of the abuser at the shared home and tell the abuser they have to move out immediately, which would protect you, keep you and your family safe. You can always request law enforcement to accompany you while you're going back into the home if you feel like you're in danger. Next. What if you need help filling out this form? Understandably, they can be a little complicated. Ask your local legal aid society for assistance, like HERA, Housing and Economic Rights Advocates. We can always provide you with domestic violence aid societies all over the state. So call a local domestic violence society, call HERA to give you those referrals. There are several family law clinics at many courthouses which will help assist you in filling out this form. And there's always places that you can go for referrals to help you if you want to fill it out yourself as well. Next slide. Assistance paying the mortgage. So what if you get a move-out order, which is great, but you still can't afford the mortgage payments? Well, a survivor can ask a court to order the abuser to pay mortgage in this situation, also rent, but that's for another topic, or other liens as part of a restraining order request. You would just have to attach an explanation of why it's urgent that the abuser pays this mortgage. Like if the abuser is the only source of income for the family, or if you'll lose the home if it's not paid. Next slide. This is what that part of the form looks like. So you would say here, click that box, say, I asked the judge to order the person to make these payments, and then you would list a reason why. Next slide. So assistance paying the mortgage. Is this you, Audrey?
Yeah, I'll take this part. Thanks, Megan. All right, so you may be stuck in this position where you and the abuser are both borrowers on the mortgage. And it's, clear that he's either you received a kick-out order, you're not getting assistance from him or her paying the mortgage. So these are options that you have in terms of the loan and talking to the lender. You can get a loan modification. And if you get a loan modification, it may, either postpone and your mortgage payments for a while. That's called a forbearance, or it can lower the amount. However, there are problems often because the abuser may not want to sign the request for a loan modification, or it might be too dangerous for you to ask them to sign your application to get a loan modification. Next slide. There are options for this. It does depend on who your lender is usually. Some lenders are going to waive the requirement that you get the other party's signature on the loan modification application if you're a survivor of domestic violence and the other party is the abuser. So it depends on the lender. If your mortgage is insured by the FHA, Federal Housing Administration, they actually have a policy that says that the lender has to consider an application by a survivor of domestic violence for a loan modification without the co-borrower's participation. And the signature of the co-borrower, usually the abuser, is not required because there is, and one of the reasons is domestic violence. So if you can show that and your mortgage is insured by the FHA, then you may have a good chance of just getting a loan modification without their signature on the application. Next slide. If your mortgage is insured by these two federal agencies, Fannie Mae or Freddie Mac, their policies are sort of unclear, and they do consider reasons to waive a co-borrower's participation in getting loan modification. So they do consider someone's application for loan modification without the co-borrower's signature, but they don't specifically say that one of the factors can be domestic violence. They will consider divorce or a separation agreement as grounds to waive the co-borrower's signature. They also have language that says that the lender has to evaluate your request on a case-by-case basis, and your request to waive the other person's signature on the loan modification. So, and this is where you might want to involve an advocate like one of us at Housing and Economic Rights Advocates or another consumer rights advocate, because you can advocate and explain to the lender that the co-borrower's signature should be waived for your safety and well-being, and that the lender should follow the policy of the FHA. Next slide. So you do have, you have rights under federal law to not be discriminated against if you are a survivor of domestic violence. If you do face what you consider to be discrimination as a survivor of domestic violence and you're being denied a loan modification for the reasons that I was mentioned or for other reasons, you have the right to demand an explanation for why they're denying the assistance with your loan. And you can always, get help from an organization like HERA or other consumer rights advocates, or you can file a complaint with the Consumer Financial Protection Bureau, which is a federal agency that regulates lenders. So you have options. It might be a fight. It's best to get an advocate to help you sometimes if you're in this situation. Next slide. Do you have other options also? Luckily, there are grants out there that are specifically designed to help people who are survivors of domestic violence with financial difficulties. So here are some of the grants that you could apply for. And most of them apply to if you're an owner or a co-owner of the house and you need of your home and you need help maintaining it and paying the mortgage. One is the California Victims of Crime Program, and it gives financial assistance to victims of domestic violence who have suffered a loss, who are in financial trouble as a direct result of a crime, which could be the domestic violence. So this is a program that might provide grants for victims who've had to leave their homes due to domestic violence, need help relocating or securing their homes and getting back in. Next slide. There's also another program is called the California Victim Compensation Board Emergency Needs Program. It also provides financial assistance to victims of domestic violence, and this is for emergency expenses, which includes mortgage payments. It is intended to provide temporary financial assistance to victims who are in immediate need of help and they can't cover their own expenses at this point. Next slide. So another one that is a program that provides grants to victims of domestic violence who are struggling with mortgage payments is the California Department of Housing and Community Development's Housing Assistance Program. This program also provides financial assistance to individuals who are struggling with housing-related expenses, including your mortgage payment. To qualify, you have to meet a certain income and other eligibility requirements. Next slide. Here are two more options which allow you to apply for a grant for paying your mortgage or maintaining your household, keeping your house afloat if you're an owner or a co-owner of the house. One is called the Alameda County Housing Secure Program. It's for individuals who are residents of Alameda County, and it provides grants. The cap is $30,000. And one of the good things about this grant program is that you can apply but you do not have to have the signature of the abuser. If you're applying for a mortgage assistance, and you want a grant to help pay, for instance, a past due balance in your mortgage, you don't have to get the signature of the abuser if they're a co-borrower on that mortgage to apply for the grant. The other program is California Mortgage Relief, which provides grants, housing assistance grants, and grants to help you with paying your property taxes to owners and people that are borrowers on a mortgage. It's capped at $80,000. And also in this grant program, they will waive the signature of the abuser if they are a co-borrower. So in this one too, if you're applying for help with past due balance on your mortgage or past due property tax payments, and the co-borrower is the abuser or the co-owner of the house is the abuser, this program will waive their signature on the application, which helps you a lot. Next slide. If you don't want to take on getting a grant and dealing with the lender and trying to pay back or stay up to date with your mortgage payments, you have some other options. As you're probably aware, if the survivor is a survivor of domestic violence, owns the home, and no one is paying the mortgage, your co-owner, the abuser, is not paying for it, it may go into foreclosure, and the lender can foreclose on it and take the home. So in order to stop this temporarily, and if you are a borrower on the mortgage, you can consider filing for bankruptcy to discharge the mortgage debt, and which will temporarily stop the foreclosure, but it will discharge your liability for the debt. You can also try you can try to embark on selling the home, and find a realtor and start that process. And if you can get some third party to help you, perhaps they will communicate with the abuser, the co-owner, and convince them that it's in everybody's interest to sell it. Next slide. So if you wanted to sell the home, there's two different scenarios you might be in. If your home is worth more, the fair market of your home is worth more than the outstanding mortgage debt, then it's probably best to go through a private sale, to sell it yourself and find a realtor and sell it and pay off the mortgage debt. But if your home, the fair market value of your home, is less than the outstanding balance in the mortgage, you can do what's called a short sale. And that is when you work with the lender and you ask them for permission to sell the property at the fair market value of the property, and enter an agreement where the lender will accept the proceeds from the sale as satisfaction of the mortgage in full, even if those proceeds are less than the outstanding balance on your mortgage. Next slide. In that scenario also, let's say your home's fair market value is less than the actual outstanding balance in the mortgage. You can negotiate with the lender for something called a deed in lieu of foreclosure. And you and the co-owner, the abuser, would voluntarily transfer title to the property to the lender in exchange for a release from liability on the mortgage debt. But when you do that, it's always a caveat, make sure that any arrangement you have with the lender when you do that, or those other options, makes it clear that as a survivor, they have no further liability on the mortgage. And if you need help with this, I always recommend that you do connect with a consumer advocate organization, your local legal aid organization, to get some assistance and help you through these steps. Next slide. You may, as a survivor of domestic violence, be in a situation where you have a lien on the house. You're an owner of the property, and there's a lien that has been placed on the house as a result of coercion by the abuser, or threats by the abuser, or often if the abuser has stolen the survivor's identity and racked up a debt, which ended up being a lien on the house. So there are ways to fight it as a survivor of domestic violence. if you want to fight this lien, and if you want to, or if you want to negotiate with your lender, you really need to document the financial abuse to prove that you are a survivor of domestic violence and that you're entitled to these rights, and that they should take these special considerations for you into account. Documentation, as Megan went through before, is really starts with getting a police report when you are abused and obtaining a restraining order. Because once a survivor of domestic violence has a restraining order, it's documentation that the abuse happened, and you can use it to advocate for yourself when you're dealing with lenders or with creditors, to prove that this debt was coerced by the abuser. Next slide. So if, for instance, a survivor of domestic violence has had their identity stolen by the abuser and ended up with a debt in their names that they did not sign on to, that you can file an identity theft report with the Federal Trade Commission. And this identity theft report shows that the survivor is subject to a debt that was coerced by the abuser. The steps you want to go through is the survivor should show to the police the FTC identity theft report, a copy of the credit report, and any billing statements or information about the coerced debt, and provide and then file a police report that there was this identity theft. So there's sort of two steps. You want to file a police report with your local police, but you also want to file this identity theft report with the Federal Trade Commission. And once you do that, then the survivor should request multiple copies of the police report and the identity theft report with the Federal Trade Commission, and use that as evidence when you're dealing with lenders or credit bureaus or creditors. Next slide. Other documentation to show that as a survivor of domestic violence, you're subject to this debt that was coerced by the abuser can be a letter from a sexual assault counselor, a letter or affidavit from a domestic violence shelter, a letter from a healthcare provider or a mental health care provider, or you can get an affidavit or report from a law enforcement officer about the circumstances of the abuse, all which is, documenting evidence of the abuse that to prove that you should be considered a survivor of domestic violence and you're entitled to certain considerations. Next slide. So in terms of this coerced debt, and if you want to ask the court to order the abuser to take care of it, you can. There's law in California which allows you to ask the court, when it's issuing a restraining order or a protective order, to make a special finding that these debts were incurred as a result of financial abuse. If you go back to the temporary restraining order form that we were showing you earlier, there's a section which asks you, and you're allowed to check it, and it says, if you did not agree to the debts listed above, you can ask the judge to find that one or more debts was made without your permission and resulted from the abuse, the domestic violence. And you can ask the court at that point to order that the abuser be ordered to take care of those debts. As usual, I also, I know that this is hard to do, and I encourage anybody to get assistance from their local legal aid to go through this process. Next slide. All right, one more thing about protecting yourself. If you, as a survivor of domestic violence, and you want to protect yourself financially, is to protect your bank accounts. So you want to make sure that you close if you have a bank account in your name and the abuser's name, it's suggested that you open your own bank account only in your name. You make sure that, let's say the abuser can still access your home or your mail. You want to make sure that any checks and bank account statements aren't sent to an address which the abuser can access. And if you do online banking, pick out an email address, a username, and a password that are not known to the abuser, so they can't further financially abuse you, steal your identity, and get access to your bank accounts. So we definitely suggest that you get any direct deposits, for instance, from your work, or fund transfers, all directed to your new bank account. Next slide. If you have funds that you can access right now with in an account which is shared with the abuser, it's suggested that you move those funds into the new bank account. But that suggestion is made with a warning not to do this if this is going to jeopardize your safety. If this is going to create a conflict with an abusive, person that is in your home and may challenge you on this, don't do it. If you aren't a signatory on an existing account, then you should look at your bank statements and check for any fraud or misuse of that account. Next. Well, now I'm going to turn it over to Megan again. She's going to talk about issues you may encounter with your homeowners association.
All right, guys. So now we're going to talk about knowing your rights. So when dealing with HOAs, things can sometimes be a little more difficult. We have clients that sometimes reach out to us with HOA issues whenever they're victims or survivors of domestic violence, and we're going to help you navigate some of these situations. But the first thing that you need to know is that you are a protected class under FEHA, California's Fair Employment and Housing Act. You can't discriminate against people based on race, color, ancestry, national origin, religion, sex, sexual orientation, gender identity, gender expression, age, marital status, familial status, disability, medical condition, or genetic information. You may have noticed that being a survivor of domestic violence is not listed in there. Case law extends FEHA to survivors of domestic violence, even if it's not directly written in the Fair Employment and Housing Act, so you are a protected class. Next slide, please. So that kind of gives you the basis, something that you need to keep in mind. As a protected class, you do have protection from an HOA and code enforcement in certain situations. For example, something that we often see is in CC&R agreements with an HOA, there's what they call a crime-free clause, saying we can fine you or charge an assessment if there's any criminal activity coming from the home that you own. So Where this can get a little more difficult is if you're a survivor and you feel like you can't reach out or call the police because, oh no, then I'm going to alert the HOA to a crime happening in my home and then I'm going to have to pay an assessment. Well, these crime-free clauses can be interpreted as discrimination against survivors if they prevent a survivor from calling law enforcement. So reach out to a local aid organization if you find yourself in this situation, if you're being charged an assessment or fees for calling the police to protect yourself, if you as a survivor of domestic violence, because these clauses may be illegal. Next slide, please. So that's the California government code that says survivors of abuse and crime and individuals can't be evicted or penalized, including charged assessments or fees for calling police and emergency assistance. California state law supersedes any local existing ordinance that would try to penalize a survivor of domestic violence for calling the police in this situation. Next slide, please. So there's also something that you may, if you live in an HOA community, recognize called a nuisance abatement ordinance. Maybe there's a noise ordinance saying, oh, if you make too much noise or if you disturb the peace, we can fine you or we can charge a fee or an assessment that would allow an HOA to charge homeowner for excessive noise. Well, if this charge is due to you being a survivor of domestic violence, due to being abused, that may also discriminate against survivors, and there may be a way to fight that assessment or fee. HOA also has a third-party obligation to get involved if a member of a protected class, including survivors of domestic violence, are being harassed or discriminated by another homeowner. So if someone else in your organization is discriminating against you or harassing you as a victim of domestic violence, the HOA not only have an obligation to act, and they can't charge you a penalty if this happens to you. And if it does happen to you, please reach out to your local legal aid organization and get help navigating the situation. Next slide, please. So those are all the topics that we have time to cover today. I know there's a lot. Please always feel free to contact HERA or your local legal aid society if you are a survivor of domestic violence and find yourself in some of these tougher homeowner situations. Again, I'm Megan and this is Audrey, and I think we have some more contact information for you at the end here. This is our phone number, extension. Please put any questions you have in the chat, and otherwise, we hope you have a good day.